Hello friends, welcome to this video. Recently, the UK released new changes to immigration rules, what they normally call a statement of change. But do you really know what is contained in that statement of changes of immigration rules? Well, the changes that have just been released affect almost everyone who is either in the UK or intends to come to the UK, ranging from students to skilled workers to visitors and even British nationals. So in the next few minutes, that's exactly what we are going to dissect. We are going to look into the important details of this document. Because technically there are two documents. So we shall look at the summary one and then we pick the details from the main document. So if that is something that interests you, then make sure that you watch this video until the end and let's dive right in. Let's go. So as I said, the document is normally entitled Statement of Changes in Immigration Rules, and this one was specifically published about 4 days ago. So the document has about 135 pages, and I am not intending to go through all of that, but you can be sure that we shall cover each and every important aspect of this document in the next few minutes. Just make sure you watch the video until the end. Let's continue. So this explanatory memorandum is the one that summarizes everything in the document that was released, but it doesn't give the details. So we are going to go through the summary, then we shall be picking the important aspect from the main document so that you are able to understand exactly what they mean by these changes and how they might affect you. So here is the summary. We are not going to read the introduction and declaration. We shall go straight to the important stuff. So this is the summary of the changes they have made, and these are in relation to Trinidad and Tobago. It talks about Ukraine, EU settlement, adding children aged 18 and under visiting the UK as part of French school. It talks about British nationals overseas, and it talks about English language, skilled workers are here. There are also changes to global talent visa. Actually, there are major changes to that visa, which I'm going to share with you. There are also some changes about PhD students and many others. But in this video, I'm going to focus on the issues that I think will affect most people. Having looked at the summary, now let's jump right into the details. But before we do that, if you are new here, welcome on board. My name is Emmanuel. And on this channel, we talk about opportunities in the UK and elsewhere, whether be that work or study. So if that is something that interests you, please make sure that you hit subscribe and join this family. Thank you for doing that. And if you find the information in this video particularly useful, please make sure that you give it a thumbs up and share it with those that might benefit. Having said that, let's continue. So the very first change that we mentioned there was introduction of a visa requirement on Trinidad and Tobago. So these changes will introduce a visa requirement for nationals of Trinidad and Tobago, which means that these nationals will need to apply for and obtain a visa prior to visiting the UK. And there is a reason for that. Let's look at that. The reason is that a majority of asylum claims from nationals of Trinidad and Tobago were made at the port on arrival in the UK. This adds significantly to operational pressures at the border, diverting staff from other priorities. So apparently, the nationals of Trinidad and Tobago who were claiming for asylum did so when they have just arrived. So instead of the border post officials doing their normal duties, they were now being diverted to attending to asylum claims. And the UK government is saying this was putting too much pressure on their staff, so now they are required to get a visa before they come, so they know exactly what they are coming for. So it is bad news for the people from this particular country, but that's what it is right now. Maybe in the future that will change. During this period, nationals of Trinidad and Tobago who hold a confirmed travel booking at the time of the introduction for travel to the UK within the 6-week transition period will not be required to obtain a visit visa before travel. So let's move on to the next. So next, let's look at the changes in Ukraine, and I'm also just going to point out the important parts. So here we see Ukraine Permission Extension Scheme, UPA, launched on 4th February 2025 and provides a route for Ukrainians and their eligible family members who have already been living in the UK with Ukraine Scheme Permission (UPE) to make a further application to extend their temporary sanctuary in the UK whilst the conflict in Ukraine remains ongoing. So under this, they say it was always the intention that these individuals would be able to apply to UPE, and specific provision was made in the UPE validity requirement to ensure this was the case. However, we have identified a need for these requirements to be extended further to provide for children under 18 who were granted leave to enter the UK outside the immigration rules so they could join or stay with their parents who already held Ukraine Scheme Permission. So this is good news. The children of those people who are already in the UK can apply to stay with their parents. That provision was missing. Now they have added it. So they add here, however, we are updating the UPE validity requirements to ensure children granted leave outside the rules, that is LOTR, before the concession was in place, can be granted permission under UPE when their current permission is due to expire, in line with their parents, thus providing greater certainty as to their status in the UK. So the changes made for the Ukrainians is basically to make sure that they are comfortable and their stay in the UK is certain. So next we have changes relating to EU settlement scheme. So the main one is here. The main changes to the immigration rules for the EUSS for administrative review of EUSS decisions and for EUSS family permit are as follows: to enable a non-EEA national applicant to the EUSS to use a UK-issued biometric residence card or permit which has expired by up to 18 months as proof of their identity and nationality, and where they use such a biometric residence card, not require them to re-enroll their fingerprint biometrics. So now, if you are a non-EEA national, you can actually use that BRP that expired up to 18 months to prove your identity and nationality, and you don't need to do biometric enrollment anymore. That has been provided for up to 18 months, and it is not only BRP, you can as well use your BRC. I've been getting a lot of questions ever since I made the video of how to link your e-visa. And by the way, if you want to know how to do that, you can just click up here and watch that video. It has all the information that you need. But for now, let's continue. To confirm that a person with a pending administrative review of an EUSS decision who has not left the UK or has been granted entry into the UK except on immigration bail will not be removed from the UK. So that is also absolutely good news. So if you have an application that has been refused and you have applied for administrative review and your application is for EUSS, that is European Union Settlement Scheme, you no longer have to leave the UK, and Home Office is not going to require you to leave and is not going to remove you forcefully either. That is until a decision has been arrived on your application or your administrative review in this particular case. Another piece of good news, right? Yes. So let's move on. I don't know whether this is good news or bad news. British nationals overseas are being removed from the list of nationalities requiring an electronic travel authorization (ETA) prior to travel to the UK. This means that all British nationals overseas passport holders will be exempt from requiring an ETA if intending to travel or transit via the UK. And the reason they say is that because British nationals overseas do not automatically qualify for full British citizenship and therefore are subject to immigration control. So that means that the British nationals overseas are now like the rest of us. The UK is now saying you are not full British nationals. So I don't know whether that means you have to apply for a visa. Of course not. But that means that you are more like a person with ILR and not with a British passport. I don't know whether that is good or bad. You decide. Next, let's look at the issues that affect students. And first, we are going to look at short-term study. They have brought tighter conditions for this visa. So, appendix short-term study English. Okay, and they're saying under this, for you to get this visa, you must show a genuine intention to study. Under this, they're saying a genuine intention to study rule has been added to appendix short-term student to immigration rules. This will enable caseworkers to refuse applications where they are not satisfied the applicant on this route has genuine intention to study the course listed on their application and to leave the UK at the end of the course. So when I read this, the first thing that came into my mind was, how exactly am I supposed to prove my intention to study the course that I intend to study? Well, for that, let us look at the main document and see exactly what the caseworkers will be using in deciding your application. I think this is important so that you get your application right and not get refused. So let's look at that. So now this is the main document. The other one was explanatory memorandum. So this is the section we are talking about. The applicant must satisfy the decision maker that they are a genuine short-term student, which means they are genuinely seeking entry for the purpose of undertaking the course of study for which they have demonstrated they have been accepted onto in STS 4.2 and will not study in the UK other than for the course of study for which they have demonstrated they have been accepted onto. 4.2, so STS 4.2 is this, and will not study at an academy or state-funded school and will leave the UK within 30 days of the end of their English language course or at the end of 11 months, whichever is sooner, and will not make the UK their main home and will not work in the UK and will not engage in any business or professional activities in the UK and have relied upon funds to meet the financial requirement in STS 6.1 to STS 6.4, which are genuinely available to them for the purposes of undertaking the course of study for which they have demonstrated they have been accepted onto in STS 4.2. So these are a lot of words, but basically what they are trying to say is that in order to show that you are a genuine short-term student, first you must prove that you are going only to study the course you said you're going to study at the institution you said you're going to study, that you're not going to remain in the UK or you don't intend to make the UK your home, you are not going to work while you are in the UK on short-term study, you will not do any professional activities in the UK, and you will solely depend on the funds that you demonstrated in your application as proof of funds for your stay in the UK. So that means if you are not able to demonstrate all those points, the caseworkers are going to refuse your application. So make sure you get it right. Let's move to the next one. So here is the thing that probably all of you have been waiting for. Changes to the skilled worker route. Changes are being made to the provisions for care workers and senior care workers. These changes are being made in response to the growing pool of workers in this route who no longer have sponsorship because their sponsors have been unable to offer sufficient work and or have lost their sponsors. I think most people in the UK know one person or two who was given visa sponsorship to come and work as a care worker or a senior care worker, and for whatever reason their employer's license was revoked and they were left stranded. That's one group. Then there's a group of people who were given visa sponsorship, they came to the UK and there was simply no work and they have been crying out. Finally the government has had their cry and has decided to prioritize them. Good news, right? Yes, it is good news for those who are in the UK, but it is bad news for those who are planning to come in from abroad. However, there is a piece of good news that I'm going to share with those abroad, which you are going to use to overcome this. But on this particular point, what is the government saying exactly? Let's take a look. Now, the changes require sponsors to recruit from this pool of workers who are seeking new employment before seeking to sponsor new recruits from other immigration routes from overseas. To enforce this requirement, sponsors must provide confirmation from the relevant regional or sub-regional partnership that they have tried to recruit in this way and confirm that no suitable workers were available from this pool. This is going to be tough, right? You guys know that companies also apply for COS from home office, right? So before home office gives that COS to the company so that the company gives it to you from overseas, they have to prove to home office that we have searched the entire UK and there is no one to fill this gap in the UK. That is not going to happen, I think, sooner, because there are so many stranded people here who came as care workers and senior care workers, and that is good news for people who are here. In fact, I think this is brilliant. Yeah, it's not fun, guys, to be in this country and you're jobless. It's not fun, especially when you came on a visa sponsorship, knowing you're going to work. People at home know you left home, you came to work. They're expecting something. Yeah, even if they are not, you can't just come to this country, coming to work, and then you don't find work for reasons which are not your own fault. Okay. So guys abroad, I hope you'll understand, but also if you're abroad, there's some good news for you. Let's look at that. So here we see these changes relate only to care jobs with working locations entirely in England. Applications relating to working locations in Scotland, Wales, or Northern Ireland are unaffected. Yes, guys. So if you're abroad and now you're wondering, oh no, UK has blocked us from going to the UK for care work. No, it's only for England. For some reason, as I said in my previous video, is that many people who are abroad think that UK is England and England is UK. No, but there are other nations of the UK. So if they have blocked you from coming to England, just get a job in Northern Ireland, in Wales, or Scotland, and you'll still come to the UK. Changes are also being made to the rules concerning deductions from an applicant's salary. These changes are being made for consistency with how paid allowances for the same purposes are treated, to mitigate against sponsorship costs being passed on to applicants, and to close an unintended loophole whereby applicants could effectively pay towards their own salary through investing in their sponsor's business. Guys, this is no longer a secret that there are so many employers in the UK, not all of them, that are exploiting workers. They give you visa sponsorship. When you come, then they start making unnecessary deductions from your salary. So the workers have been crying out, and government has had this. Home Office is putting changes in this, and they want to put a stop to this. And by the way, guys, visa sponsorship should not be paid for. In fact, government guidance says that if somebody is charging you for a COS, most likely that's fraud. You shouldn't pay for a COS if that employer is in the UK. However, there may be agency fees and some other fees, but now they're putting a check on that to ensure that you guys are not investing in the employer to facilitate your own employment, which has been a cry of many people, and now Home Office is listening. Then here we also have updates to Global Talent Visa. And for this, let's also jump again to the main document. For those in fashion, this is what they are talking about: a CV which sets out their professional fashion design career to date, and 3 dated letters of recommendation supporting the global talent application, of which 2 must be from well-established fashion organizations that the applicant has worked with in a fashion design capacity, who are acknowledged as experts in the applicant's field, and at least one of the organizations must be based in the UK. And the 3rd must be from another well-established fashion organization or an individual that the applicant has worked with in fashion design capacity, who has recognized expertise in the applicant's field. In brief, they now require you to provide a CV with 3 references. Of those 3 references, at least 1 must be based in the UK. So guys, if you are planning to come on Global Talent Visa, start hunting for that. And there are also other changes that they have made. For example, if you got recognition as a group, they no longer accept that unless you can prove that you significantly contributed to the award. But mostly, they are now looking at individual awards that you obtained. For television, it's here. For tech, they are also here. And for reference, you can go through this table and see what they are meaning exactly, and then you'll be well equipped. Let's move to the next one. So a change has been made to appendix students to exempt PhD students from academic progress requirements if they are following their academic supervisor to another education sponsor to complete their studies. This change allows PhD students to apply for further permission from inside the UK to complete their course rather than having to leave the country to do so. So it has been unfairly that a PhD student would have to leave the UK and reapply for student visa to a different institution using a different visa sponsorship from that institution. Now, you can just apply from within the UK to shift to the other university without having to leave and go back home, which is good, right? Yes. In relation to this is very exciting news. Let's look at that. Removal of postgraduate doctor or dentist provision from the student route. So these changes remove the provision of appendix students for Health Education England to sponsor students following recognized foundation programs as doctors or dentists in training. This provision is no longer required as HEE has surrendered their student sponsor license. Access to these programs is now via the skilled worker route. These changes also remove the foundation program in medicine or dentistry from the list of relevant qualifications for graduate route and the associated definition of postgraduate doctor or dentist from the introduction to the immigration rules. In summary, before now, if you are coming to do DCT, dental code training, that is for a dentist, I will speak for the dentists. Someone else might speak for the medical doctors because I might make a mistake. Let me speak about what I know. If you are coming for DCT, it would require you to find a placement as an SH from a teaching hospital, which is a full-time job, by the way. However, you were required to be sponsored as a student by Health Education England, specifically by your relevant deanery. Now, that's not required. All you need to do now is find a placement and get a visa sponsorship from that teaching hospital, and you come as a skilled worker. Because it is a job anyway. I think this is absolutely great news for those coming to do those specific trainings. And talking about skilled worker, there is also a change that they have made in terms of settlement. Corrections are being made to definitions and settlement requirements relating to the following. This is the whole group: skilled worker and so forth. And they're saying this clarified that the qualifying period for settlement as a lead applicant in these routes must consist of the time spent in the UK as a lead applicant, not as a dependent. Dependents may qualify for settlement separately based on time spent in UK as a dependent. So in other words, if you come as a skilled worker and for some reason you shift to being a dependent, your time you spend as a dependent does not count towards your settlement. But I think this has actually been going on. If you come on one visa and then you change to another, your time actually resets to 0 and you start counting afresh. With that, guys, I think I have taken the time to cover all the important aspects of this announcement, and you may not need to do it yourself. Otherwise, thank you for watching, and if you have watched it up to this point, then I want to assume it has been good. Please make sure that you give it a thumbs up, and I'll see you in the next one.